And the recording is on. Welcome to week number 5. This is week number 5 of Contemporary Issues in Criminal Justice, Monday, February the 1st, 2021. 8 more days from now, and this class is over completely. And so you want to make sure that you got those assignments in. Everybody heard my announcement already last week that I'm not taking any more assignments from weeks 1 to 3 after the completion of week 4, which was yesterday at 11:59 p.m. Central Standard Time. And so from this point on, we are dealing with weeks 4, 5, and 6. And be aware that, well, getting a little ahead of myself. We'll see in just a minute. I'm going to share my screen. All right. So, all right. So we scroll down. You see that adversity springboard success, which you all are aware of. And week number 5 is going to be under here. You'll see this. Now notice this, what I said is that Mondays, 8:30 to 9:30, weeks 1 to 5. I'll see you all again Thursday at the same time, 8:30 p.m. Central Standard, for our week 6 lecture. Professor Wright, why are we having a week 6 and a week 5 lecture? I'm glad you asked, but you should already know. And here's the reason for it right here. Because it doesn't make sense for me to do a lecture, and it wouldn't benefit anybody for me to do a lecture next Monday, when the class ends Tuesday. So you see here, there we are. This is where we are, okay, with our module topic, criminal procedure, and which is one of my favorite areas, along with that writing communication, the professional communication skills, module 3. And then I like the community policing, but my favorites are 3 and 5. So your initial post is due tomorrow night on DNA, which is a great thing. I'll talk about that. I didn't get the chance to have the advantage of it because I practiced law and it was coming in as I was leaving out. So then you'll notice Thursday at 8:30 p.m. we will have another lecture. And that lecture is for week 6. Okay, week number 6. And then your reply post will be due on Saturday as normal. Your written assignment, warrantless searches, will be due on Sunday. And then your key is supposed to pop up. Come on, click on it again. There it is, live classroom. So you'll have that. Okay, and then on Thursday, I will talk about this and this. But just a reminder, this week, 2 times you'll know, class ends absolutely without hesitation on the 9th at 11:59 p.m. Central Standard Time, unless there are other arrangements that have been previously made. And that's it. That's all I can say. And so the point of the matter is that you want to make sure that you understand that if you submit it on the 10th, which means at 12 o'clock, you're going to have a problem. And that problem is you're not going to have it graded. So, okay, give me a second here. Let me take a swig of this water. I'm drinking something new today. It's called Hint. I don't know if any of you ever had any, but it means what it says. I figured it did. It's a blackberry hint, but it's just water, and I like it because I need to be doing that with my weight. Since this course has started, your professor has lost nearly 30 pounds. Yay! Because I tried, not because I'm sick. So that's a good thing. All right. So any questions about this? No, I'm not even asking you to let me know because I know you already know. So let's go into module number 5. Let's close this. I don't like to leave that open. Okay, let's go down here. Criminal procedure. This is what I spent most of my time in my career as a criminal defense lawyer utilizing criminal procedure, which told us how we operated, how we applied criminal law, is how the charges came about, but how we proceeded through the system has to do with criminal procedure. And so one of the big issues involves search and seizure, the Fourth Amendment of the Constitution. I've said this in a couple of other classes that I teach, that in criminal law, the first 10 amendments to the Constitution, also known as the Bill of Rights, the most important 3 are the Fourth Amendment, search and seizure, the Fifth Amendment, self-incrimination aspects of it and other things that go with it, and then the 6th, speedy trial, but more importantly than that, the Sixth Amendment, right to counsel aspects. And so that as individuals who are heading in law enforcement should be aware that there is what we call the Federal Rules of Evidence, which tells us what evidence is acceptable in court that you can utilize as evidence. And followed by them is what we spent most of our time in one class. This was called evidence. I took one class and it was called evidence. Matter of fact, I teach an evidence class periodically in the bachelor completer program, which I love teaching. But the evidence section tells us what is admissible. However, we spend most of our time dealing with the exceptions where you don't have to obtain a warrant. You'll discover that the Fourth Amendment says that you must obtain a warrant in order to obtain an arrest or search and seizure, and it's based upon the standard of probable cause, unless it fits in one of the exceptions, like plain view, or you might have stop and frisk, or Terry stop as we call it. You might have other things as well. So there's a whole bunch of them, and when I teach constitutional law, I kind of discuss those as well quite frequently. So anyway, in this assignment, you're going to, as it says, this first statement, warrantless searches are important for officers when collecting evidence. Yeah, because if you don't do it right, us defense attorneys will come down on you real heavily and file what we call a motion to suppress. The motion to suppress is filed before the case starts so that we can weed out evidence that was not properly obtained by law enforcement, which is why, just throw it out to you now, O.J. Simpson was found not guilty. That's exactly the reason. I know all about that. I've talked about this in my other classes, and you guys are familiar with that. You that are here are familiar with me talking about that, because of my experiences of being a criminal defense lawyer and reporting on for the media, the O.J. Simpson case, but also finally with my relationship that I established with the late Johnny Cochran, who was the attorney. But the LAPD boggled that case, and the prosecution didn't have much to work with, and then they didn't do the best of jobs either. So the key thing is, and this is what I used to tell people, as a defense lawyer, one of the biggest parts that I can do before trial is to eliminate stuff that might be the smoking gun or the thing that might convict a person because the police violated the Fourth Amendment and did not obtain a warrant properly, or that the warrant was obtained on false pretenses, such as no, this basic lying because you have to submit an affidavit before a judicial magistrate, or that you obtain the evidence by not satisfying the Fourth Amendment search and seizure, and that you did so without an exception where it fits under, or you went beyond the search requirements with a warrant in those kind of situations. So anyway, so what you're going to do, and it says collecting evidence that may otherwise be lost, and that's what I just said, or endanger the lives of people in the community. So why is it endangering the lives of people in the community? First of all, number one, people can be killed and injured in situations. That's kind of like the situation that those of you are familiar with the Breonna Taylor case. There may be instances like that. There may be other instances, or there may be instances where cold-blooded people who are criminals are set free. And people says, how do you rest as a defense attorney when that happens? I'm glad you asked. The reason is because everybody's entitled to a defense, and that's the absolute truth. And so as a result, though we lawyers still recognize that it has to be based on some evidence that we present. Not like some people who think that you can just go into court without evidence because you feel something happened. No, that's called losing the case. And if you are a lawyer and you know that something is not factual and it's based on theories that are not true, and you propose to represent your client with that, you can probably lose your ticket as well. Sounds like something that's getting ready to happen in a few days in the Senate with impeachment, but it's the same thing. So anyway, searches and seizures and the constitutional rights and are there, and we as officers of the court, which are what attorneys are on both sides, you have to base it on fact. So you're going to read these two scenarios, and based on the things that are talked about, the lecture notes in this module. Now remember, the lecture notes, they are not what I exactly say, but they are stuff that we've already put in through the help of the course designers to help you understand this module. And we're going to talk about those. We already started talking about them already. So you're going to determine that you're the officer, and would you be permitted to conduct a warrantless search? Now, in order to do so, you're going to have to be able to tie in one of the exceptions, which we'll come to in just a minute. So remember now, read the following scenarios and determine based on the notes whether you as an officer would be permitted to conduct a warrantless search. Now, here's the thing that you're going to determine. Reading scenario one, and I'm not going to read it out loud, but you're going to determine as the prosecutor thinking about possible exceptions to the Fourth Amendment search and seizure rule to make an argument about why the evidence should not be excluded. Professor Wright, I don't know about those exactly. I remember them a little bit. That's all right. We're going to help you out today. Scenario number 2. And then I'm not going to read all the facts, but it says, as the officer, would you tell the gun owner about why you took the weapon and why it did not violate the Fourth Amendment, considering the facts? And then scenario 3, you're going to say, now, imagine you're the judge. So remember, you got 3 roles you're wearing here. You're wearing here as the officer in the first one. Oh no, as a prosecutor, I'm sorry. And then the second one as the officer. And then the third one, here comes the judge. Consider the exceptions of the Fourth Amendment regarding the area around an arrested person that can legally be searched without a warrant. Hey, they actually told you the exception, and you don't even realize that, but you will in a little bit. So in a 3-page paper, and don't be afraid to go further. I love reading papers when students are not intimidated by trying to get it in 3 pages. No, just write, but don't do less. And the reason why we say 2 pages at a minimum is because we believe that in order for you to do justice to the requirements of this assignment that we're going to talk about with the rubric, and also what I've already shared kind of with you, is that it takes at least 2 pages. Remember, it's double spaced. So if it was 2 pages or 3 pages single spaced, then it'd be twice as much writing. But double spaced, because that's APA requirement. And so you're going to explain the basis for justifying or not justifying each of the 3 warrantless searches you must read. So now here's what I want you to do. Do me a favor. When you write these, let me know which scenario. Caption yourself as scenario 1, scenario 2, scenario 3. I hate it when I read a student's paper and I'm reading it and they jump right from the others. It's supposed to be a new paragraph. It's a new topic. It's a new approach and all of that. So separate it out. That's a formatting issue. It really, it irritates me and it's hard for me to follow. So explain the basis for justifying or not justifying each of the 3 warrantless searches you read. For each 1, 2, 3, give reasons why the officer would be allowed to conduct a warrantless search, or why the suspect's rights were violated by the warrantless search. Okay. APA formatted, in-text citations, not a citation, a cover sheet, as well as a reference page. It says you may want to refer to the lectures in this module. Well, you already will have that information. So it's very, very, very important that that be done. Microsoft Word, do not send me a PDF. Y'all already know that though. All right. And you know too that we're doing 7th edition of APA, which is different from what you guys started out with, which is 6. And actually, to be honest, I think the running head is not a requirement anymore. A lot of people didn't realize that. Were you guys aware that running head is not a requirement anymore? You can type in the chat box. Yes, thankfully it's right. I thought it was crazy. I really did. It didn't make sense to me. So I was ecstatic when we had our training and we were discussing the issue that they were doing away. So I asked constantly, what are you trying to prove with that? You know, but anyway, it's gone, so we don't have to deal with it anymore. So now let's look at what was that? I got that chat quick. Well, that's okay. We won't take points off for doing it. Yeah, old habits die. You know, yeah. Yeah, it don't matter. It's more work for you. That's really what it is. So I'm not going to penalize you for that. I never penalize my students for the running ahead rule anyway in grading papers. I never have. There are professors who do, but I refuse to do it. And the reason why I didn't is because I had a feeling based on the logic that was explained to me about why it existed, and I'm not going to get into a discussion of APA in depth, is that it didn't make sense. I was like, huh? Okay. Yeah. Anyway. So let's look at the rubric. Due Sunday the 7th for 45 points. So now there are 4 columns that you're going to write your paper from. Which column are you going to use? To do your assignment? I've only said it every week in class. Yes, yes, that's it. 4, or mastery. I tell my students this constantly, and yep, the school appreciates the fact that I do this because of the fact that I say, yeah, I asked when they were doing this, because I hated this rubric. My rubrics I used to put together had only 1 column, and I think it was Patty Laney. You guys know Patty Laney? Yeah, yeah, yeah. Patty Laney and I always joke with each other because she was a prosecutor and I was defense attorney. Uh, yeah, she sure is. She sure is from Fargo. I always tell her, I say, "You're from Wells Fargo, huh?" And she would laugh whenever I said, you know. Yeah, they're cool. I like Patty. Patty and I work together real well. Rose Pagacic is another one. But Patty and I um, have worked together on putting together some things. As a matter of fact, she was the one that helped me with drugs and crime to make some sense out of it. Went back when it was 11 weeks. So yeah, Rose, yeah, Pagacic, yeah, she and I worked for a little while on domestic violence before I had some issues and I had to drop out of development that. So I don't like course development. I've learned that already. So anyway, we're going to go with mastery. And that's a habit that I always try to breed into my students. Notice when I always talk at the beginning of my courses, I always talk about don't call me or ask me or text me or email me ever to ask me how to get a C in my class. Don't do that. I'm not going to answer you. You know, I want you to excel. I always talk to my students very much, a lot about maximizing on your ROI, return on investment, by getting good grades. I know school is not all about grades, but um, unfortunately, employers do look at grades in terms of determining who they're going to hire. And maybe you'll get to PF one day. There are some law schools I know that don't give grades. We had grades at Northwestern, but there are a lot of law schools that are doing away with that and getting pass fail. It's enough that if you do the requirements that the professors set out to you, that you pass the course. They haven't reached that stage at a lot of colleges. So anyway, the scenario 1 for 15 points, you're going to satisfy all of these requirements. Now, it goes without saying that you're going to have citations to support your statements in number 1. It goes without saying that you're going to have the same in number 2. And then the 3rd. Now, remember, the rubric does not mention APA, even though the ones I used to do, they did, is because APA is understood that that's the format anyway. I also make it pretty clear to my students, if you go back to the course homepage, in any class I teach, I say all written assignments must be an APA, unless I state otherwise. And I generally don't state otherwise, okay? So it's very important. There's some exceptions to that, but citations and references. Like, for example, those of you who took Introduction to Corrections, before they changed it to a 5.5 course, you had 11 week and you had to do that project, and then you had to do an interview. You didn't have to have references, you just had to have citations. So anyway, so notice, to get all of your points, so you want to get 15 times 3 or 45. You don't want to get anything less than that. Notice you'll lose 2 if you're over here. So you'll lose 4, 6 points. So then you lose 6 points from 45. And here you lose 4 points. No, more than that, 5, all the way down. And then here, it's just half the points, which is not passing. So we don't want to go there. All right. Any questions about that assignment? I spent a lot of time talking about it, but I'm also giving you lecture at the same time because I'm talking about warrantless searches. Any questions? Okay. All right. I'm one professor who spends a lot of time going over assignments. So there's sometimes students say, hey, professor, I didn't understand such thing. I says, did you listen to the lecture? Well, no, I was trying to see if I could help get some help from you. And I says, listen to the lecture, then call me back after that. Most time I don't get calls back because I'm very thorough in how I do that. And I do that purposely. I'm not going to tell you the answers to some questions and you don't go ahead and listen to the lecture, and you only listen to the lecture so you can get the key phrase, you know. Yeah. So then the discussion post. And you're going to talk about this DNA issue. And you'll notice that the Fourth Amendment always pops up in almost everything. In June 2011, the Supreme Court voted to allow police to take samples from offenders arrested for felonies, DNA samples. And there were certain privacy. And remember, what the purpose of the Fourth Amendment is to deal with privacy, so that so law enforcement is not invasive. And so anyway, the DNA rules changed in 2011 for the better. Because, one of the things about DNA that is something, it came about as a tool that actually helped solve, it did several things. It helped solve missing individuals. It helped solve crimes because individuals who committed crimes, their DNA was what got them convicted. The example that I like to give, and this is for people who are in Illinois. Kara, you're here in Illinois with me, I think, right? Oh, you're in Wisconsin. Okay, all right. That's another class. I got another student, but and I know Nicole that you're not. But anyway, the point I'm bringing is that in Illinois, and this was a national case, there was the famous Brown's Chicken Massacre that took place in a town called Palatine, Illinois, where some guys came into a Brown's Chicken restaurant just about at closing, and they killed the people, put some of them in the freezer, but they killed them. And for many years, that crime went unsolved until somebody, opened their mouths and started talking. But just without any corroboration, one of the things that nailed the individuals, or one of the individuals, was the fact that they decided to eat some chicken. And they ate the chicken and left, some of they ate the chicken and left it there in the garbage and so forth. Your DNA was on that chicken, and they took that chicken and they kept it and preserved it, and then they were able to match it from the individual who was alleged to have committed the crime, and the DNA nailed him. So that's that's an example of a case. You can Google it and check it out. It's called the Brown's Chicken Massacre in Illinois. You can probably find it under that. But there are other crimes across the country where DNA used. But one of the great things that I like about DNA from the perspective of a defense attorney is that DNA has allowed individuals to be acquitted and found not guilty. One of the guys I know, and I'm drawing a blank on his name. I think Kara, you might have reminded me his name. He's now he's an African American attorney in New York now, but he was convicted of raping a female in Wisconsin, and I think DNA got him out. Do you know who I'm talking about, Kara? Was that you that gave me that information? I know his name. I just can't. I always forget his name. Yeah, maybe it wasn't you. It was somebody in Wisconsin that knew about it, and I have a lot of Wisconsin students in my classes. But anyway, he was exonerated, and DNA helped to exonerate him, and he moved back home to Illinois where he had came from, and then became a lawyer, passed the bar, and then he went to New York, and that's where he is now, and he has a wrongful conviction um, program. I know his name, and I've talked to him several times, and I can't remember his name off the top of my head, but he's one of my friends on Facebook and all of that. I got so many. But anyway, DNA is important because it has also resulted in the yeah. Okay. That was you that told me. It was Jared Adams. Yeah, that's who it was. Didn't you tell me that before? Was that you that told me that before in another session or something, Kara? Yeah. I knew it was somebody in Wisconsin. It was one of my, and I thought it was you. But yeah, Jared Adams. That's who I'm talking about. Real sharp young man. He's written a book, but he's in New York, and he actually clerked for either a Supreme Court justice or somebody. But he has a great story. I've encouraged him to write a book, and hopefully one day they'll do a movie about it. But anyway, needless to say, that you're going to, in at least 250 words, give your opinion as to whether you think DNA samples prior to conviction is a violation of the Fourth Amendment and why, and giving your information. But again, I'm a big fan of DNA, and so there's arguments on both sides. So your initial post again is due tomorrow night. All right. And then your live classroom lecture is due that Sunday. And those are your assignments. So let's go into the module as we already have started. And let's talk about these things right here, these three things here. So why do we have law in the first place? Law is to maintain order, not law and order, but to maintain order so that we are a civilized society. And I used to always ask my students the question, give me another word for laws. Give me another word for laws. Can you tell me another word for laws? Some that you nope, you're being deeper than you have to. Something that you learn as a kid. There you go. Yeah, and it's right here anyway. But that's the answer. And I used to always talk about this in criminal law, is that it says rules or laws act as guides of our behavior while providing fairness through due process, which means in due process, the very simple thing is that you have a right to face your accusers, the right to receive the information. One of the things, the first things after a person is charged is that your attorney for defense will file what we call a motion for discovery. And in some areas it's called disclosure. And what it means is that that motion is filed and presented by the defense to the prosecution and filed in court to give the prosecution the opportunity to provide you what evidence that they have to substantiate the charges and allegations. They cannot withhold any evidence. Withholding evidence that's exculpatory is a basis for a dismissal of the charges and or a new trial, and can also result in sanctions for that prosecutor. If you haven't seen, but if you saw the movie My Cousin Vinny, which is one of my favorites, he discovered Joe Pesci as the attorney didn't know that the other side had to give him access to the witnesses, to the information that they had in their possession. He thought that the prosecutor was being nice to him until his girlfriend, Melissa Torme, who played a sharp young lady in that movie, I think she got an Oscar for it. She said, no. She says, they have to give it to you. And that's part of due process, so that you can have the evidence to say, what are the things that you have that cause you to prosecute me? So due process is a constitutional right. Laws are often referred to as statutes or codes, and they're federal and state laws. And so we utilize these to determine what the time and punishment that a person gets and all those kind of things. For example, you know when a person is a felony by how do you know if a crime is a felony or a misdemeanor? How do you know? How do you determine that? I've said this before in classes before you guys have been in, or me, especially if you took criminal law with me. What's the difference in a crime, in a person? Yep, yep, that's exactly the difference. The sentence. So if the sentence or the statute says you stand a possibility of a year or more in jail, which results in probably prison, then you learn that from corrections, then you find yourself with a felony. If it's under a year, it's a misdemeanor. So anyway, we operate on the basis of these things. And so I'm not going to go into all of this. But the criminal justice system, as we have learned, and you have learned earlier, is that it consists of the law enforcement aspect and the investigative aspects. So they're combined as one. One is really the police and others called detectives. The adjudicative, which is the place that you go, which is the court. And then if you're found guilty or plead guilty, you go to the next stage, which is corrections, which is consisting of probation, jail, or prisons. And then you have the appellate court if you have a right that has been violated at the trial court level. And be aware that most cases are not reversed. It has to be what we call the judges can come back with a decision in the appellate court and it says it's an error, but it's harmless error. We used to always say that's an oxymoron. That's defense attorney talk, though. So anyway, so there's individuals who represent people. You have the public defender for people who can't afford an attorney, which, by the way, I always remind people that they are lawyers. They're not just, a lot of people, says, oh, you don't have a lawyer, you got a public defender. I know some really good public defenders who are top lawyers, and some of them became judges as well. So then we utilize the U.S. Constitution and the Bill of Rights. We've kind of already talked about that. And the Fourth Amendment brings us down to what I said earlier. It says the Fourth Amendment protects. Yeah, public defenders are good. I was offered an opportunity to work with the public defender in my county, Cook, when I was living there, because she was my class. No, she was a couple years ahead of me, but she was still my classmate at Northwestern Law School. And we had at least 2 or 3 from there that were what we call PDs, and they were the chief public defenders and wanted me to be their first assistant. I was ready to retire then. I had 2 opportunities: become a first assistant, and defense attorney and the public defenders, or I was offered an opportunity to become a judge. I didn't want either one. I was done. And it was only teaching that brought me back to it. So, but, I always paid attention to what was happening in the law. So anyway, the Fourth Amendment protects us against unreasonable, that's the key phrase, intrusion, searches, and seizures by the government unless a warrant is obtained. I told you about that. And under certain circumstances, the government can search or seize without obtaining a warrant as long as they provide proof sufficient for probable cause, thus making the action reasonable. These are known as the exceptions. And here they are. Well, these are some of them. And I'm not going to go over each of them because I won't be able to cover all the material. But what you can do is, for example, consent searches. And you could click on it and it tells you what consent. Now, I'm going to close this down, but you can go back and look at it. Be aware that when you talk about consent, it has to be consent. So I always like to ask my students, if I'm surrounded by police and they ask me, and they have weapons, can they search my car, the trunk of my car, or my house or something? And I say yes. Would you think that that might be a consensual search or not? What do you think? You think that could be considered consensual or not? Well, you just contradicted yourself in your statement in the legal terms. The answer is no, because of the rest of the stuff that you said, because you might feel coerced. If you go back and look at consent searches, consent is valid if the third person has equal opportunity over the business resident and can be concluded. The absent person assumed the risk of might permit a search. Okay, search is not allowed, and they give some examples. But here, these are some examples. Hey, here's one. Parents may consent to a search of a child's living area if the parents have routine access to the area or the child's not paying rent. So they're not a tenant. Let a kid try to pull one off, says, oh, I pay rent. I clean the house and so forth. Yeah, I hear you. Anyway, the consent must be consensual. That was my point. So it must not be like in an intimidating situation. Exigent circumstances, I'm not going to talk about that. Open view and plain view are almost the same. But I like plain view because plain view is if an officer conducting a lawful traffic stop or is in a home which they've entered for lawful reason, hear me, and sees contraband inside the vehicle, you may seize the contraband. So here you go, you invite the officer in, and the officer's in the house, and somebody's freebasing, and the officer sees that. That's in plain view. It means what it says. So, you know, so you can click down. The old pat down frisk, that's what we call the Terry stop. There it is right there in black and white for you. And the purpose for it pretty much is to protect the officer. So I'm not going to go into all these. Oh, I do want to do this one because of the fact that officers may thoroughly search the persons, that the individual, for all arrestees who are taken into custody. And this shall be conducted as soon as possible after the arrest and before transporting the individual. So they want to make sure there's no contraband or any weapons. Evidence of any crime which is discovered in the course of valid custodial search may be used to support any later charges. But also when you get to custodial, you oftentimes have a situation where you might want to question them. What is it that you better do when the person is in custody? When you need to question them. What is it that you better do? Come on. Nobody remembers? It started in 1966. And you already know. One of my law professors hated it because he felt that they were talking bad about him. What is it that you must do as an officer if you're going to question a person who's in custody? All right. Yeah, I know you already knew. I know both of you know that. And all of you who are looking at this tape will know it. Yes, you have to do that. If you don't, the statement is not admissible. On a motion to suppress, it's out and you messed up. You might give good evidence, can't use it. So anyway, those are the exceptions that you need to consider. All right. Now, so dealing with criminal procedure, we have statutes, as we already said, and there are things that are involved. Although there may be exceptions, it says most crimes contain three elements. First, the act of the crime, or what we call actus rea. The intent, that's in the mind. Mens rea, and a concurrence of these two, meaning that in order for an individual to be accused, must have had the requisite intent. That is why people attempt to use insanity or diminished capacity as a defense. So I'm sure you both have seen Legally Blonde, right? You saw that? Yeah. You remember when Elle Woods was giving her client a question about mens rea, and the judge told her, move on. I know what mens rea is, she said, but anyway, but it has to do with the mind. It's one of the state of mind that you're in when you commit the crime. All right, and the act itself is called actus. So combination of actus rea and mens rea can result in your committing the offense anyway. So the elements of criminal procedure are the rules of how you gather information, search and seizure, and we talked about self-incrimination. That's, remember I said the fourth is search and seizure, self-incrimination is the fifth, the right to an attorney, that's the sixth, during interrogation, a right to against excessive bail. Anybody remember what amendment has to do with a right to against excessive bail? You know what amendment is involved there? The same one that has cruel, unusual punishment. There we go. Get the question mark off of there. Yeah, you didn't have to put that question mark. I always, whenever my students put a question mark on there, it's always, I'm going to jump all on you. Why are you questioning yourself? Yes, you were right. It's the Eighth Amendment. Yeah, you had to, yeah, because I kept saying it, right? Don't do that to yourself. You know, that's what students is. Oh, I was gonna, I knew, I thought that was it, but get the buts out the way, you know. So, but anyway, the point of the matter is that the Eighth Amendment is what's involved. Okay, and the right to a speedy trial by jury, that's the sixth, and then the right against cruel and unusual punishment, back to eighth. And so we have what we call the exclusionary rule, which applies to the Fourth Amendment and the Fifth Amendment and the Sixth Amendment, which means that if you violate the constitutional rights in either of these amendments, the exclusionary rule says that this evidence cannot be used in a trial. That's what we call the exclusionary rule. It means what it says. A lot of times in law, the words and definition are contained in how they describe it. So just like I said earlier about a good formula to help remember when the Miranda warnings is required is arrest plus interrogation equals Miranda. Okay, and then you know what the rights are and things like that. By the way, I'm going to ask you this question. How do you know when a person is under arrest? How does a person know when they're under arrest? Or what do you consider as when a person is under arrest? Yay! The field goal is good. The touchdown, you get 6 points, plus 2 for kicking. Yes. No, 1 point for kicking. Anyway, I'm trying to, well, no, you can get 2, but you have to not kick it in. Anyway, that's sports. But yes, that was right, perfectly. And that was what I was looking for. See, I try to make sure that my students understand, and then it carries over from class to class. And it'll carry on over into your profession as well. So it's important to understand the rights are open to interpretation. And that it says that at the foundation of these rights were not originally in the Constitution, but came about through cases, such as the right to counsel came under the infamous, or now famous, case of Gideon versus Wainwright, a 1963 case, which, by the way, also was extended in Illinois versus Powell. So it became clear that individuals had the right to an attorney, not before Gideon, and then if you couldn't afford one, then you required. That's why actually the language of Miranda actually incorporates that part of Gideon versus Wainwright. There's a movie that I saw with Henry Fonda where he played Gideon, and there's a book called Gideon, what's the name of it? Gideon's, I forgot the name of it, Gideon's something. When we used to use it in our classes, but I have the book somewhere in my library here. Anyway, it talks about the story of the Sixth Amendment and how important it is, because people just don't know the law unless they're representing themselves. So other elements of criminal procedure have the rules of evidence, which we already talked about, so I'm not going to, but it says must govern the admissibility of evidence against defendant, and all guidelines are formalized in written form. Okay. So, so it says, for example, the prosecution presents the state, represents the state against the defendant, and defense attorney or public defender represents the defendant or the accused. And it's a system where we represent each other in terms of our clients. The people are represented by the prosecution, and advocates for both sides do their best to offer defenses as well as prosecutions within the law. Okay, and then here's the last thing I'm going to say about that, is that some scholars characterize the adversarial process, stating there may be differences between law and science in the way that truth is uncovered. However, DNA, which is a technological advance, fingerprint analysis, surveillance, by such as wiretapping, and now we have surveillance in other forms. What's another popular form of surveillance that is utilized in courts and in cases that can determine how and whether or not a person committed a crime or not? What do we have all over the place? Yeah, well, I was getting ready to reach for this, but it's actually cameras. So yeah, cameras. Now we have body cams on the police. We have dash cams on the cars. We have the things that look like street lights, but they're actually cameras. People oftentimes have cameras on their homes as well. So yes, absolutely. Okay. Gideon's trumpet. Thank you so much. That's it. That's the book, and that's the one about it. Thank you. Did you just remember that, or were you in the class when I talked about that, or did you just Google it? It's okay if you Google it. But anyway, but yeah, Gideon's Trumpet, a very good book. We used to have it as required reading. So this is the final part, and we're a little bit over, but here are the steps. So yeah, that's all right. That's what Google is good for. You can do that. When I was in school, our Google was the books themselves. We didn't have any of that. Or either, as I tell people, my Google was Encyclopedia Britannica, World Book Encyclopedia. Uh, you guys probably heard about that, but and you may even know about it, but Google is the way. Yeah, Encyclopedia and World Book Encyclopedia. Yeah, that was, oh, okay. So that means you're old too. Okay. Yeah, yeah, you're old. Yep. You're almost as old as my oldest daughter, who's 50 now. So people says, you got a 50-year-old daughter. I said, well, I'm 70. He's 71 in May. Oh, wow. Anyway, I digress. So steps in a criminal procedure begin, first of all, as we say, with the arrest, and then you have appearances in court within 24 to 48 hours where you have a bond hearing, and that is outlined in a 1943 case. The next step is the preliminary hearing, which we defense attorneys loved because it gave us a chance to get a taste of what the possible evidence was. And at the preliminary hearing, it was determined whether or not there was sufficient evidence to hold the case over for actually a full trial. However, the prosecution loves to use the grand jury hearing. And one of the things that you should be aware is when an indictment is returned by grand jury is that the prosecution is the only one who's there as far as attorneys. There is no defense attorney available at the grand jury. We can get the transcripts, but the grand jury, and it says some states don't use grand juries, and in these states there would be a preliminary hearing where a prosecutor files a document called information. That's what we do, and determines if there was probable cause to bring in. Then there's a hearing that takes place called the preliminary hearing. where we have a chance to question. I have won cases at the preliminary hearing stage where it never went beyond that, and there was not sufficient evidence to take it to a full trial, and the charges were dismissed. But with the grand jury hearing, the prosecution presents their evidence and their evidence alone, and there's nobody to witnesses, and then the grand jurors vote what we call a true bill to determine whether or not to take it to the next level. Once an indictment or information has been filed, then the individual is arraigned. Now, an arraignment is very short. If you once again get a chance to see the movie My Cousin Vinny, at the arraignment, you do not talk about your case. There's only two things that you say as a defense attorney, and you're going to be asked, how does your client plead? That's the judge. And there's only one answer, really most defense attorneys give, and that's not guilty. If the person pleads guilty, then you can go right to the, there's no trial, and then we go into plea bargaining. So the point of the matter is that, so once the indictment is returned, then you're formally arraigned, and so you'll actually be again informed about the charges, and then the defense attorney and defendant have an interest to decide whether or not their client is the most common one is not guilty. All right, defendants and their attorneys will normally agree to a plea deal if they plead guilty, but normally not. Okay. And then the prosecutor will offer a plea deal if they're unsure of their ability to win at trial. Plea deals are commonplace. And I've said this before. It says as many as 94%. Now it's gone up as of 2014. But it used to be 90%. Do you all, if any of you took the classes way back when I was teaching criminal law, and it was a full 11 weeks, we used to tell students that 90% of the cases were resolved by guilty pleas and plea bargaining. And plea bargaining is a necessary tool because, by the way, if more than that go to trial, the system's going to be bogged down because there's not enough judges, courtrooms, and all these other things. So it pretty much boils down to, so now it's 94%, which makes sense. Makes sense because there's more guilty pleas. And again, that comes about because the police have done their job well, or the evidence, and then things like DNA will nail a person down. If a person enters a plea of not guilty, then the trial begins. And then, I already told you this, that the trial begins, the defense attorney will request a suppression hearing in an attempt to disallow evidence or suppress evidence before it's admitted. And then if there is no suppression hearing or the judge rules to allow the information, then we go to what we call voir dire, or jury selection, where we question the jurors. Any of you guys ever been a juror before? It's interesting. I've been selected for jury, but they always get me out of there. My daughter made it on. I was surprised she made it on, and she hung a jury. But generally, the jury eliminate people that have been defendants. I mean, not defendants, have been the victims or family members victims. So we use what we call challenges to select the jury. Peremptory challenges are challenges where we can dismiss a person without giving a reason. However, we cannot use it in a racial form. So I'm not going to go into all those details because I've talked about this before. Challenges for cause: if either of the attorneys believe that the potential juror will not be impartial. For example, if you ask the juror, and this happened in My Cousin Vinny, says, do you think you could be fair and impartial with these individuals? Or either do you believe that if they're found guilty that you would subject them to the death penalty? And the answer from the juror was, fry them. And the prosecutor says, I'll accept her. Well, obviously that person would be disqualified in reality because they were already biased. People lie, though, to get on juries. We had some of that going on with the O.J. Simpson case, by the way, and every other case I know. So once the jury is selected, then opening statements are made. Incidentally, opening statements and closing arguments are not evidence. They're just the attorneys presenting their summaries of what they expect to prove. Closing argument is a summary of what they have proved. So then there are, as they say, three types of evidence. There's what we call direct evidence, which is fact without requiring the judge or jury to draw an inference. So this is evidence that's clear for people to see. Circumstantial is indirect evidence, or helps the jury draws a conclusion. A lot of cases have a lot of circumstantial evidence. And then real evidence consists of physical evidence, such as tire tracks, notes, fingerprints, DNA, or weapons. And when you have DNA and stuff like that, you have experts to come in. Once evidence has been submitted and examined, the attorneys are ready to give their closing statements. I talked about that. After the closing statements, the judge will then issue what we call instructions to the jury, and the jury then will deliberate. Something you said about forensics, I want to get that in there. Yeah, forensic evidence is real because it's based upon like DNA. It's based upon science or information. So yes, it's real evidence. And so then the jury is then, if it's a high profile case like the O.J. Simpson case, then the jury is sequestered or locked up. I've had friends who've been on juries and they've been locked up for months and they weren't able to go home, anything. And so the jury deliberates, and one of the first things they do is they select a four-person, and then the jury has to come back with a unanimous verdict. If they cannot unanimously agree, then it's called a hung jury. Sentencing then is the final stage. If a person is found not guilty, there is no sentencing stage. And sentences can be imposed by the judge and sometimes jurors as well. And usually the sentencing stage is a second hearing that takes place to determine how much time the person gets, or if there is a plea, how much time that person gets. So, and that's it, good people. Any questions? Okay. All right. So, okay, let me see what that question was. Can judges go direct to sentencing? You mean what, after a verdict? Generally not, and I'll tell you why. That's a good question. Because of the fact that what happens after a person is found guilty, there is a stage for mitigation and aggregation of a crime. And the other thing is that there's usually ordered what's called a PSI. PSI is a pre-sentence investigation where the probation officer, the probation department, conducts research into the background of that individual to determine, their criminal history or lack of criminal history. There's information presented about that individual's background, whether they've ever committed a crime. Then also there are witnesses that come in to testify. So that's a separate hearing. So actually the answer is no. Generally, that's not the case. Yeah, the probation officer does the pre-sentence investigation, or PSI as we call it. Yeah, because the fact that the judge can't sentence the individual unless they know the history of the individual, because that's not part of the trial. So that's the answer is yes. Yes. Every time I've seen cases, there has been. Anything else? Well, that's not true. That's not true. Because with mandatory minimums, you still need the history, because they don't have to go with the minimum. They could go with the maximum or something in between that. And then they determine the background of that person to determine. So mandatory minimums means that that's as low as they can go. That doesn't say how high they can go. See why it makes sense to have that? Okay. So the key thing is to try to determine, is this a bad person? Also, I had a young man I represented years ago in one of my last serious cases who committed a heinous crime, rape and murder, of a meter maid, and I tried to get him to accept a plea of 40 years, which would have meant 20 years for him because he would have got good time back then. And that was in 90, I want to say 94. So that meant, and he'd have been out now, but he decided to go to trial. And so they did a background check on him and everything and found out that he had never been in trouble, but that um, the most that the judge could give him was natural life. He couldn't give him the death penalty because he committed the offense at 17. So he got that. But yes, yeah, it's important to have that. And when you ask that question, if you stop and say, oh, wait a minute, there's a maximum and there's a minimum. The minimum is only so that the judge can't go any lower. Now, the judge could go lower if, for example, the person is pled guilty and they plead to the lesser included offense, and that person is found guilty. Let's say a person is guilty of the higher offense and the lesser included offense, then the judge has the option to sentence them on either one or the other. That's kind of what happened here in Illinois that made people mad about this police officer who shot his name was Laquan McDonald, with the 16 shots. So, yeah. Anything else? One or the other. Usually it's not both. And we have what we call concurrent sentencing, and we have consecutive. Concurrent is when it runs together, but consecutive is when you finish one and then you go into the next one. So a person can, for example, be sentenced to 120 years with 4 terms of 20 years, or rather 40 years, 40 years, 3 terms. And if it's given concurrent, that means for each day that they serve part of the other. But if it's consecutive, then they start one and finish it, and they actually will serve a longer period of time in jail. Even if it's good time, it would still be 60 days, 60 years at least. So, anything else? Okay. Well, guys, I will see you Thursday, but I want to give you a key phrase that you need to put in. Criminal procedure. That's what I want to give you. Give me that criminal procedure and you'll get your points for module 5. So do not forget that this week, people say, oh yeah, next Monday we're going to have a lecture. No, we're not. We're not having a lecture next Monday. Okay. All right, guys, I'm going to say good night to both of you. Thank you for showing up, and Nicole for showing your face and you having your uniform on. I already knew what your uniform looked like because I think I told you my niece works for the same company you work for, and I've seen her in her uniform. So, yep. All right, guys, have a good evening. Continue to stay safe, and again, as usual, what to do if you need me. So take care.